My name is Clay Crawford. I'm an officer and director of the Missouri Organization of Defense Lawyers, and I'm here to testify in support of this bill on behalf of Model. Model supports this bill for all the reasons previously stated. The only thing I would add and graft off of Mr. Beckerman's example with regard to the permissive use is just a vehicle to try to explain this legislation, is that the way the common law of Missouri has developed in his example, if the trial judge, the judge who is going to decide the uncontested case between the person who was injured in the accident and I believe Representative Colonia was the driver in that example, that judge could, at the request of the plaintiff, enter a finding that there was in fact permission to operate the vehicle, when perhaps in reality there was not, or at least it was a contested issue that could be decided by a jury under a certain set of facts. The way the law is developed in the state of Missouri, an insurance carrier would never have the opportunity to have its day in court, so to speak, on that issue, which would be determinative of its coverage. And it would not have had its day in court in the underlying action, even if it was allowed to defend, because the attorney that it would hire to defend, in this example, Representative Colonia, would be ethically obligated to represent Mr. Colonia's interests, not the insurer's interests. So what's so important about this legislation is to provide a safe harbor for insurers and, frankly, insureds to make sure that these issues of coverage are decided on the merits, and that at least at some point in the process, the insurer has the opportunity to fairly litigate factual issues and conclusions of law that bear on its coverage obligations. These carriers are asking no more than to be placed on equal footing with other businesses and contractual parties in the state of Missouri.
All right. Any questions? Representative Colonna.
Thank you, Jim Clark.
Go right ahead.
First off, I would use my mic.
Yeah, okay.
I thought it was loud enough. Ooh. First off, I love your organization. You guys are good people. You really are. And you know, a lot of other lawyers out there would say that you guys aren't, but you have a hard job to do, let me tell you. And the folks I know in the civil defense bar are fine, upstanding people that I enjoy working with. Would you agree with me that the present status of Missouri law, generally speaking, focuses more on making the injured person whole and trying to determine, in essence, who has the ability to pay? And what I mean by that is, we have the small business that has the policy. I'm the driver of the car that you're saying stole it. If you offer the reservation rights and I say no and walk away, where is this person left?
If I may answer that, it's a great question.
Yeah.
In public policy in the state of Missouri, that this legislature has come up with is that injured person has the absolute right to be secure in the fact that there should be $25,000 worth of coverage available. That's the public policy of the state, and that is preserved in this bill. I believe there's a provision in it that says nothing should be construed to get around that public policy and that right. But with the statute 537065 that's been discussed and the cases that have developed, Smiths versus Great American, DHP versus Secura, Shadell versus Barplan, and now the most recent case, which is actually mentioned in the House bill, the Higher Holdings case. The result is, if in this uncontested trial there's a judgment for $10 million, that could be deemed consequential damage. And so this carrier that wrote the $25,000 policy would be on the hook for $10 million.
I get it, but I guess what we're disagreeing on is where the problem exists. I keep hearing the problem exists when the evil plaintiff's lawyer and the person that was hurt get together and collude on making a bunch of money. I'm saying that present law addresses the problem from the standpoint of insurance company trying to weasel out of what may legitimately be their responsibility to the detriment of the insured, meaning the small business.
If I could, I'm glad you asked the question.
And I apologize for using colorful language
No,
like that.
no, collusion, it's really important to understand.
The weasel part I thought was colorful.
The collusion part, I think, is a key piece of this, because in every other state I'm aware of, collusion is considered to be cooperation between two parties who are natural adversaries. The person who caused the accident and the injured party in our adversarial system are supposed to be adversaries. The truth comes out because they litigate that issue. And collusion in most states is when a plaintiff and defendant cooperate to the detriment of an insurance carrier. Missouri law requires to prove collusion, you have to prove fraud, actual fraud, as an element of collusion. And I'm not aware of any other state that requires that.
But if you have walked away, that's why there's no fraud, because I'm not engaging in any fraudulent activity because you decided to walk away from that fact scenario.
And it certainly, and I would just respond briefly and respectfully, if these situations only occurred where an insurance company took one look at that situation and said, we decline, yeah, it's absolutely fair. But where there's a unilateral right under Butters for the insured to get to reject the insurance company, that's why it's reservation of rights.
To reject your potential to withdraw. Again, I think that's present status of Missouri law encourages you to defend, to stay in the lawsuit, to ultimately see it through to judgment, right?
And thereby give up all the coverage rights, yes.
Well, coverage rights up to the policy limit, right?
Used to be until higher holdings, and now it's up to whatever the judgment is.
Well, if there's a little bit of bad faith, or if there's, and now we're going to get into a factual disagreement of the latest case, but we'll save that for later. But that's really all I wanted to get out, is that I think from the way, and truthfully, I try to put myself into the shoes of, I did workers' comp defense for a little while. Anyway, of a defense lawyer, and think to myself, again, from a public policy perspective, what do we really want? And I truly believe present status of Missouri law encourages you, and I love my farmers friends, so I'm going to say farmers, the farmer's defense lawyer to stay in the case, which in all reality may mitigate the amount of damages at the end of the day, even if you, are 99% correct on no, you're not covered. But I would rather err on the side of, making sure that people have lawyers to defend them than when they thought they paid a policy, when they thought they were covered, when they thought they were insured, than kowtowing to, well, is that a technicality or not? So that's, I know this could be a cocktail conversation for 3 or 4 hours, but I want to make sure I got that out there. Thank you, Mr. Chairman.
Any other questions for this witness? I've got one, I guess, real quick for you. Did I hear you say earlier that there's cases where the judge has determined, for example, that coverage did apply even though the insurance company may have found out that coverage shouldn't have applied?
Yes, Mr. Chairman, and in fact, not even maybe the ultimate determination of coverage, but where in the underlying case, best example I can give you is the reported decision that I had the opportunity to argue in the Eastern District, where in the underlying case it was determined that there was what's called an insured contract, a contract for indemnity between a general contractor and a sub. The facts in that case were there was no piece of paper, there was no contract, there was no invoice, there was nothing. But the trial judge was just presented with a set of facts and asked to enter judgment on them. Later in the coverage case that I argued in the Court of Appeals, we were precluded in the underlying case and subsequently on appeal from arguing whether or not there had been a contract in the first place, because that had already been decided. And it was decided in a forum where the insurance carrier, because it had to decide whether or not to stand on its reservation of rights and chose not to, that it never had the opportunity to litigate that case. That fact, excuse me.
Okay, thanks. Any other questions? Okay, thank you. Make sure you fill out a form.
I did, thank you.